Good day, Crime Talk aficionados. First on the docket, the defense begins their case in the Chad Daybell defense. Rex Huerman gets his house searched this morning. The alleged Delphi murder suspect and his attorneys are not getting along with the special judge Francis C. Gull. Should Donald Trump testify in his own defense? The Moscow Mule Mom needs a new attorney. And I thought teachers were supposed to be straight-laced goody two-shoes. What has happened? And then finally, our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. If you haven't joined us in a while, you know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and make sure you hit that little bell for notifications. Yes, that little bell, sometimes it gets turned off, not by you, but by YouTube. So make sure it is hit so that you receive notifications of when we go live or put up new content. And yes, you can listen to us anytime on any of your favorite podcasting apps. All right, let's go ahead and open the record for May 20th, 2024. And first on the docket, the defense has started its presentation in the Chad Daybell case. That's right, the prosecution rested last week. Yeah, we had that little brouhaha about the whole, can we amend the indictment at any time because the prosecution messed it up? But we're over that now. And now the defense began their presentation with Chad Daybell's daughter, Emma Murray. She and her mother, Tammy Daybell, worked together at the same elementary school, and she lived nearby. Now, Ms. Murray also testified that her mother's health had been declining in the last year or so, and that she was noticeably more tired, going to bed much earlier, even sometimes before dinner on some nights. Now, she spoke of her mother's anemia and claimed that even carrying grocery bags left bruises on her mother's arms. She said that Tammy Daybell was an extremely private person and that she never spoke of her health concerns or issues going on with anybody else. Now, as you may recall, Chad Daybell is on trial for first-degree murder in the death of his wife, Tammy Daybell, who, according to some, appeared healthy in the weeks before her death. He's also charged with killing his new wife, Lori Vallow's children, 7-year-old Joshua J.J. Vallow and 16-year-old Tylee Ryan, as well as conspiring to commit first-degree murder of each of the 3 victims. There's also grand theft and 2 counts of insurance fraud. Now, like I said, this testimony today covered a wide range of topics, and there were lots of objections by the prosecution, most of them calling for hearsay. Now, like I said, Ms. Murray described her father's religious views as fundamental, many of which are not typical of most Latter-day Saint beliefs. And on one occasion, Ms. Murray described her father exercising as being inside of her that was causing her anxiety. I felt like an actual person was trying to control me, she said. Now, prior to asking Ms. Murray at length about Tammy Daybell's fitness, Ms. Murray said her mom would shake her arm to get more steps on her Fitbit because she competed with her family to win a fitness challenge. Now, prosecutors early in the trial used data from her Fitbit to show her activity was above average until she actually died. Now, Ms. Murray also testified that her mother regularly ascribed death percentages to people, as did her father. Now, the defense had asked about Ms. Murray's ability to access family computers and searches, what the definition of SSW directions were made on Chad Daybell's account the day that Tylee was last seen alive, used to suggest that Chad Daybell was planning to burn the children's body the next day. Now, Ms. Murray said she searched the internet for the wind direction on September 8th and at her parents' home. I was trying to be an amateur meteorologist. It was common just to jump on the computer. There wasn't any login or anything, she said. Now, concerning the increase in Tammy Daybell's life insurance policy before her death, Ms. Murray testified that the Ballard Insurance Group encouraged teachers at the women's school to increase their life insurance. And Murray said they both did so without telling or consulting their husbands. Now, in the morning of Tammy's death, Murray said she went to the house before 7 a.m. and said her father was more distressed than she had ever seen him in her entire life. And Ms. Murray testified that she was the one who refused an autopsy for her mother, saying her father never expressed an opinion either way. I don't think autopsies should be done on anyone, she said. Well, Chad Daybell's son also testified, Garth, and the son-in-law finished up today. He was just about ready to be cross-examined at the time that we are filming this video, but the court ended for the day. He was talking about access to the property, who had access to the tools. So it's, obviously, I think Ms. Murray came across as very defensive, particularly on cross-examination. Clearly, they love their father and father-in-law. They basically were asked that they were not aware of what was going on when asked questions about the relationship that their father had with Lori Vallow. But the defense is trying to explain away these things that the prosecution has made a very big deal about so that they can look, it was completely innocent, and that our dad is just kind of naive guy and he just got duped. Or that's the whole defense for the Chad Daybell matter. We'll see. Testimony will continue tomorrow. Next on the docket, Rex Huerman got his house searched this morning. Now, Rex wasn't there because he's in custody for all those alleged murders that he committed, but neither was his wife and 2 children that still reside in the house. So the state police swarmed the Massapequa Park home of the alleged Gilgo Beach serial killer, Rex Huerman, and they had a new search warrant. Well, because they would need a new search warrant. They couldn't just go in unless they had consent. The question is what gave rise to the new probable cause so that they could go in? What something of evidentiary value do they now believe is there? Were they listening to telephone conversations, perhaps? That's going to be my guess when more information comes out. Anyway, the police arrived early Monday morning at the house. Like I said, neither his estranged wife or children were there. And it's not clear, like I said, what elicited the new search warrant of the property. But multiple law enforcement agencies were present, including the big command center. Now, the district attorney there in Suffolk County declined to comment on anything as it relates to the Gilgo Beach task force, other than they are continuing their investigation. Now, like I said, Mr. Huerman is in custody. He is awaiting trial and is facing charges for killing 4 women whose bodies were found wrapped on a stretch of Ocean Parkway near the Gilgo Beach. Now, he was arrested back in July of last year and was initially charged with killing Melissa Barthelemy, Megan Waterman, and Amberlynn Costello. And then in February, he got some more charges for the death of Maureen Brainerd Barnes. Now, Huerman, like I said, has pled not guilty to all accounts and is awaiting a trial while he remains in custody. Next on the docket, the attorneys for Richard Allen are just not getting along with the judge. That's right, Judge Frances C. Gull. She canceled the pre-trial evidence hearings that were scheduled to begin this week in the Delphi homicide case. Now, the hearings were meant to address several pivotal motions, including the possibility of barring certain evidence from being presented during the trial, which is currently scheduled to begin in October. Well, last week, Richard Allen's defense team asked Judge Gull to postpone the hearing as they pushed for more time to depose a psychologist assigned to Allen's case during his stint at the Westville Correctional Facility. Now, if you don't know already, Mr. Richard Allen is accused of murdering 2 teenage girls, Abby William and Libby German, back in Delphi, Indiana, back in February of 2017. Now, the judge initially denied the defense team's request to push the pretrial hearings back, which were scheduled to begin tomorrow, on Tuesday. But she reversed course on Monday and canceled the hearings outright. Now, in the order, she cited to the defense team's latest effort to remove her from the case as her reason for delaying the pretrial hearing. Now, in filing the motion to qualify the judge noted, and let me get to this, I think it's kind of shows the tone that the judge and everybody is having as it relates to this. The judge wrote in her order, "The defense has also filed a second verified motion to disqualify the judge and a request for findings of fact and conclusion of law upon denial of the request. If the court denies this request, filed on Friday, May 17th, 2024 at 3:04 p.m., as the court is now required to review and rule upon the 42-page pleading, the court is compelled to cancel the hearing." That's right. Mr. Allen's attorneys are making friends and influencing people. I don't think that the judge really likes these attorneys at all. As you recall, Judge Gull kicked the attorneys for Mr. Allen off the case. They ultimately appealed to the Indiana Supreme Court. They were put back on the case, and the judge has been rude, short, denied every motion that the defense has made, and basically said, why are you wasting my time with having to do anything with this case? So it continues, and of course, obviously now the trial is not set till October. It was supposed to start in May. It was supposed to start this week, but guess what? It didn't, because the defense said, we're ready. And then, well, there were scheduling issues because the judge had only docketed for 2 weeks, even though the prosecution has 102 witnesses, not to mention the defense thinks they'll need 2 weeks. Now, of course, the judge, who is sitting on special assignment in this particular case, couldn't accommodate her calendar to go beyond that. So therefore, Mr. Allen waived speedy trial, and the trial has been set into October. Next on the docket, the three-ring circus is coming to an end in New York. Now the big question is going to be, will Donald Trump testify? And frankly, based upon what I have read and heard about the proceedings that have taken place, I'm not sure he has to. All right, remember, the prosecution has to prove this case beyond a reasonable doubt in the hush money case. The hush money case is alleged for paying a star, Stormy Daniels, $130,000. The question now becomes, was this done to interfere with the election, as now has been alleged? So what was the big link? Well, we heard Stormy Daniels go into great detail, which was completely irrelevant, I might add, and probably the reason, if there is a conviction, there will be a reversal. But we had Michael Cohen, the alleged fixer for now former President Trump, who is a certified known liar. And he will tell you that under oath because he's been convicted of lying to Congress. He's been been told he lied to a judge, and the judge said, you are a liar. So it's not like we're just making this up, ladies and gentlemen. And well, guess what? Like I said, Cohen admitted while on the stand to a series of lies on the witness stand. And on Monday, today, he admitted to stealing $60,000 from the Trump organization. All right, so let's get this straight. The prosecution rested his case after the star witness, Michael Cohen, took the stand for a third day as the court awaited the bated breath to find out whether former President Trump is going to testify. Now, the jury is finished for the day, but the defense attorney, Todd Blanche, is arguing that the prosecution has failed to prove their case and that the judge should dismiss it. It's a standard motion for judgment of acquittal or directed verdict. Regardless of where you are, it's the same principle. Now, the standard practice in any defense proceeding to make that motion, and it's usually denied because the judge must view the evidence in the light most favorable to the prosecution, drawing all inferences in the favor of the prosecution. And the judge should not substitute what he believes as the 13th juror and basically let the case go to the jury. But the defense argued anyway, said, hey, there is no evidence that the president attempted to hide or falsify records in any way. Even the own prosecution witnesses said it's not like Mr. Trump was doing the books. People were putting the data entry in. A bill came in. They classified it as a legal expense. And he also says there's no conspiracy or effort to influence the outcome of the 2016 election, which he says the prosecution put at the heart of their opening statement. Now, as you may recall, prosecution in this case never really articulated what the federal crime or the other crime was that these records falsification would make it a felony. So you had to falsify records, but you had to do it to hide another crime or commit another crime. So now they said it was election interference. Anyway, kind of the big news, though, came when Mr. Cohen admitted under oath that he stole $60,000 from the Trump organization and revealed that he dealt with an apparent photo extortion blackmail attempt involving the ex-president's daughter, Tiffany. Now, the attorneys for Mr. Trump introduced evidence that showed Mr. Cohen and his former attorney, Mr. Costello, spoke repeatedly about 75 times despite Cohen's testimony that he considered Costello shifty when they were first introduced. Now, Mr. Cohen described his theft of the $60,000 as more of a self-help remedy because he thought he was entitled to a little more money, so he just basically overbilled it and kept a little money for himself. Wow. Self-help. I'm going to have to remember that on the next theft case I do. It wasn't really theft. He liberated the money. It was more of a self-help procedure that he was taking to make sure he got paid. Anyway, so the gentleman that the defense wanted to call today was a guy by the name of Robert Costello. Now, Robert Costello was an attorney for Michael Cohen early on. And through a series of releases, Costello has stated that what Michael Cohen has said in the past, that Donald Trump was involved in things of that nature, are complete lies and fabrication. He has sent various emails and things like that to the prosecutors in this case, thinking that it would go towards the grand jury. He even testified before the grand jury, but he was not allowed to answer any of the questions that was related to the information they had that the key witness, Michael Cohen, was in fact lying. So this guy is now Mr. Cohen is not some lightweight. He is the former deputy chief of the criminal division for the United States Attorney's Office in the Southern District of New York. That's a big responsibility, okay? Obviously, he's in private practice now, but he used to be a big hitter, and he knows how to prosecute a case. Some of the people he's represented in the past include Chief White House Strategist Steve Bannon, George Steinbrenner, and Leona Helmsley. Now, so this gets interesting because prosecutors asked Cohen during his direct testimony about various times that he and Costello mentioned Giuliani during their communications, the former mayor, right? Anyway, Cohen said Costello was offering a back channel to Trump through Giuliani at a time when he was feeling vulnerable after the FBI raided his apartment and his office. So Blanche then walked Costello through a series of questions attempting to take on the contention that he was applying pressure on this potential witness to keep him in the fold, so to speak, not pressuring him to don't talk to the prosecution. Anyway, that came after texts showed him referencing Rudy Giuliani and telling Cohen he had friends in high places. Did you ever put any pressure on Mr. Michael Cohen to do anything? Blanche asked Mr. Costello. No. Ever pressure him to interact with Rudy Giuliani in any way? No, he responded. He said he absolutely considered Cohen to be a client. Cohen said the two did not have a retainer agreement. But we all know that the attorney-client relationship forms once somebody seeks that advice, whether there's a retainer agreement or not. One should be filed in the future or prepared in the future, but it's not required. Anyway, whose interest did you have in mind? Blanche asked him. Exclusively Michael Cohen's, the attorney testified. Now, the defense and prosecution engaged in a long legal battle in court regarding Costello's testimony. As a result, the judge set some real narrow parameters of what he could be asked and what he could not be asked, essentially limiting scrutiny to questions about the two different versions of events that Michael Cohen had described in relation to the Stormy Daniel deal. Now, Judge Merchan said he didn't want a trial within a trial. Okay, Judge Merchan, the man who's made this case go on forever. Anyway, as a result, the prosecutor raised objection after objection, which were all sustained by Judge Merchan. In fact, Merchan is looking directly. In fact, at one point, Judge Merchan was looking directly at the prosecutors, anticipating each objection. At times, Costello answered anyway. And after many objections, Costello shakes his head at one point, and the judge had to remind Mr. Costello that when an objection is sustained, he should not answer. Another objection comes in, and Costello says, Jesus. There was kind of a big scene at one point where Judge Merchan repeatedly and quickly upheld objections from the prosecutions. At one point, the attorneys had finished his question. There was a quiet objection from the prosecutor, followed by a split second later, sustained by the judge. And after yet another sustained objection, Costello said, geez. And just a few feet away from the bench, his head towards the witness, the judge said, sorry. Costello didn't answer, but looked away, but was silent. And another point, when the judge was there, The judge sustained the objection, and Costello, a former prosecutor himself, followed up with strike it. The judge then asked everybody to stop, and he addressed Mr. Costello. In a forthright voice, he apparently said, "I want to discuss with you some proper decorum in my courtroom. If you don't like my rulings, you don't say, geez, you don't give me a side eye, and you don't roll your eyes. You don't say strike it, because I'm the only one who can strike the testimony from the court." Now, Mr. Costello appeared to look back at the judge, who then exploded. Apparently, Judge Mershon said, "Are you staring me down?" He then said, "Clear the courtroom." The court officers yelled at members of the public and told everybody to get out into the hallway. When they returned after several minutes, Costello was still on the witness stand, looking as if he apparently received quite a tongue lashing from the judge. Now, another little twist is there's a defense expert, a guy by the name of Bradley Smith. And the question is, what will he be able to testify to under the restraints that Judge Mershon has put on him? Now, Mershon apparently took the weekend and considered arguments by both lawyers on both sides, but opted to limit what the former Federal Election Commissioner chairman could talk about to avoid a three-way battle of experts where prosecutors would bring in their own witness. Now, the judge would also provide jury instructions about matters of law related to the campaign finance law. So the judge ruled that the former FEC chairman can testify about the purpose and background of the FEC and relevant definitions from election law. An expert is not permitted to present and interpret the law, the judge said. Experts can ultimately testify to the ultimate question of fact in a case. The judge should have read that. So he could have been able to give his opinion as to whether there was a violation of any election law. But the judge says, nope, can't do that. Now, Mr. Smith was originally appointed by Bill Clinton and was put forward by Republicans joining the commission back in 2000. Now, he has argued against campaign finance restrictions and authored a book titled Unfree Speech, The Folly of Campaign Finance Reform, and he's argued for the right of corporations to spend funds in federal elections. The United States Supreme Court cited Mr. Smith's analysis when they issued the opinion in Citizens United, which allowed basically free money to go anywhere as it relates to campaigns. Now, I'm kind of against that. I get it's free speech. I do. But the reality of it is, people go into government to loot the treasury and enrich their friends. And I think, if we're going to have people making donations, then everybody should know where they got their money from and what were they expecting in exchange for that money, because they always expect something. So the big question is, will Donald Trump testify? I don't think he has to at this point. Has the prosecution proven this case beyond a reasonable doubt? Well, we'll only know once the jury reaches a decision. Now, I know the former president has said, only mafia people assert the fifth. No, not true. And everything that this president and his defense wanted to try and do was to not put the president on the stand. That's the way defense attorneys try a case. And that is to put up the evidence through other people that you need to get through your client. So the defendant never has to testify. Just a general rule of thumb. And I can tell you, I've won more cases when a defendant does not testify than when he does. There's more opportunity that they would screw it up. And let's face it, if there's anyone that can screw it up on the witness stand for himself, it would be Trump. Next, the Moscow Mule Mom needs a new attorney. The defense attorneys representing Corey Richins, the Utah mom with 3 children and a children's book that's accused of killing her husband back in 2022, well, they filed a motion to withdraw from her case, citing an irreconcilable and non-waivable situation. Now, Ms. Richins is charged with attempted murder, aggravated murder, and drug possession after she allegedly poisoned her husband of 9 years, Eric Richins, back in March of 2022, with illicit fentanyl as a means to collect millions in life insurance funds. So the attorneys provided notice that they have to do, and they say that in their motion, they have a professional duty to withdraw from its current representation of the defendant, and the ethical mandate for withdrawal results from an irreconcilable and non-waivable situation, and obviously this is what they need to do. Apparently, it first emerged from the civil cases in which the firm had been representing Miss Richens, but it imputed to the firm as a whole and thus requires the firm to withdraw from its representation of the defendant in the criminal proceedings. Now, the defendant's lead attorney, Sky Lazaro, noted that in the matter emerged from a hearing in her client's case held on May 15th, during which Richens' preliminary hearing was pushed back to June 18th. To properly safeguard the defendant's constitutional rights, the court should immediately grant the firm's motion to withdraw and should immediately appoint new counsel to continue the vigorous defense of the criminal charges against Miss Richens. In another filing back in May, Richens' defense team filed a motion to disqualify the state prosecutors and specifically Chief Prosecutor Brad Bloodworth due to his involvement in severe violations that compromise the integrity and adversarial fairness. Now, Lazaro alleged prosecutors improperly obtained evidence, including jail calls and a letter considered confidential due to the attorney-client privilege, to help build their case against Ms. Richens. Now, the state responded by saying, "We will respond to the motion to disqualify after the court addresses the motion to withdraw as counsel." That's going to get interesting. It makes you wonder if maybe one of the civil attorneys said something to her that was in there and maybe it was to not be honest or something. I don't know. I hate to speculate, but you really got to wonder what would give rise to it at such a late date. And prosecutors allege that Corey, then 33, killed her husband in an effort to collect millions in insurance funds and flip a $2 million mansion that was under construction at the time of Eric's death, an investment that he and his family did not approve of. And the night Eric died, police allege that Corey and her mother, Lisa Darden, were celebrating Corey's recent closure of the mansion in question. Now, Corey allegedly poured her husband a cocktail laced with fentanyl, the Moscow Mule, and the medical examiner determined that Eric had more than 5 times the lethal amount of the illicit opioid in his system when he died. The examiner said they found 16 nanograms of quetiapine, describing an atypical antipsychotic medication that is widely used as a sleep aid. The next day, Corey allegedly closed the deal on the mansion alone after her husband was pronounced dead. Following her husband's death, she wrote a children's book about grief titled Are You With Me? And made local media appearances promoting the book, in which she discussed her husband's death as her inspiration for the book. Well, we'll see what happens when she gets a new attorney. Obviously, if there's an irreconcilable conflict, the attorneys have to get off, whether the judge or the prosecutor believes it, likes it, doesn't matter. They got to get off. Next, what happened to teachers? When I was growing up, teachers were boring. They were straight-laced goody two-shoes. What has happened? So we have a Virginia second-grade teacher and her husband are accused of being on drugs on school property. So Candace Carter is accused of having drugs in her classroom at the Spotswood Elementary School in Fredericksburg, Virginia. A school resource officer noticed Carter appeared to be under the influence of something, and according to the police, her husband, Christopher Carter, was outside in the car school parking lot with their 2-year-old child. Anyway, Christopher Carter also allegedly was under the influence, and when the police were dispatched, they thought that he was overdosing. Now, according to the police, he was unresponsive and given Narcan twice, and the sheriff's office said the toddler was physically okay and is now in the care and custody of social services. Apparently, the sheriff's office said students were examined, and it appears that none of them were harmed in any way, and that the classroom was professionally cleaned out of an abundance of caution. Needless to say, Candace and Christopher Carter are charged with felony child endangerment and neglect. Candace Carter also faces felony drug charges and is being held without bond. Christopher's bond was set at $5,000. We have more issues with teachers these days, ladies and gentlemen. I don't know. I think if my kids were young again going to school, I would want boring teachers. I would want like nuns teaching my kids. Oh, yeah, we used to, huh? And at least you could diagram a sentence. I bet some people won't even know what diagramming a sentence is these days. Well, the nuns used to make you do it all the time. Next, our dumb criminal of the day. All right, quick story here, right? An intoxicated motorist gets pulled over for some erratic driving in Iowa, provides police with a state ID card that states that the defendant was, get this, 8 feet tall. Yeah. Well, Joel Soloranza Valleda was behind the wheel of a 2016 Ford Focus, apparently all over the road when he got pulled over. Needless to say, the police ask for his ID. They see some open beer cans, and a little bit of meth in there as well. Needless to say, things aren't going well for the driver, Mr. Valleda, and he provided police with a Minnesota ID card. Well, they ran the ID check, and Mr. Soloranzo Valleda, well, nothing showed up. And they were a little surprised when they noticed that the phony ID advised that he was 8 feet tall, when in reality, he's 5'8". He was arrested on several charges, including, obviously, DUI, providing cops with a false ID, and a warrant check showed that he was wanted in another Iowa county for, guess what, another operating a motor vehicle under the influence. He is currently locked up in the Lyon County Jail, and his next court date is May 23rd. All right, everybody, thanks for watching. Hope you enjoyed the show. We'll see you tomorrow. And remember, tomorrow, it's Tuesday night. We're going live, 6 p.m. Mountain Time. See you then. And remember, the Constitution matters.